Chapter 12 involves crimes against the public, and crimes against the public include offenses that affect quality of life, group violence, and vice crimes. Examples of these would be disturbing the peace, drug offenses, and prostitution, as well as certain ways we assemble. And we'll talk about each one of those. They also are known as victimless crimes, meaning there's no actual person who was harmed. These victimless crimes, they are prohibited because one of the functions of criminal law is to express a shared sense of public morality. So these crimes are generally based on moral or value judgments. And as we discussed in Chapter 3, we have constitutional protections. If conduct prohibited involves an individual's status in society or right to assemble or right to speak, these are all fundamental rights. If the law is doing one of those, it can be challenged in court, and the courts will, the terminology is strictly scrutinized. You'll see that if you're going to read through Supreme Court cases and such, when a court is determining whether or not a law is constitutional based on one of these fundamental rights, they will strictly scrutinize that law. And what that means is the government is required to show a compelling government interest as to why that law is in place. This creates a conflict between legislators trying to ensure peace, tranquility for the citizens, and judges upholding the many individual protections, including the Bill of Rights. So there has to be a balance between order and constitutional liberties. We're going to first talk about disorderly conduct. It is also referred to as disturbing the peace. Generally, it criminalizes conduct that negatively impacts the quality of life for citizens in any given locale. It is usually an infraction or violation level offense. It is here in New York. In Texas, however, it's a misdemeanor. But it is important in that it preserves citizens' ability to live, work, and travel in safety and comfort. So I give you this example that I'll circulate back to a few times. Giving a police officer the middle finger. Is that disorderly conduct? Think about what is the legislator's compelling interest for passing that kind of law versus free speech. Is it free speech to give law enforcement or a police officer the middle finger? Let me give you disorderly conduct's elements. They are as follows. You need a criminal act, of course. Generally, there are 3 the defendant must do or not to do. Make a loud and unreasonable noise or obscene utterance or gesture. Think about that middle finger. Obscene must refrain from doing that. And to talk about noise, the quality of the noise is judged in the setting where the noise occurred. Like a noise in a quiet rural neighborhood at 3 a.m. can be softer than a noise made in a loud and busy area like a city street during peak hours. It's a little hard to charge disorderly conduct in New York City. However, in Plattsburgh, it is a common charge that is issued, especially downtown in the evening time. And usually, though, it comes with a warning. First, there's a warning, and if the conduct continues, then there will be an arrest for disorderly conduct. Engage in fighting or threatening or state fighting words. Remember our fighting words from Chapter 3 when we discussed free speech? The intent to likely cause the other person to react in a way that would lead to a fight. Create a hazardous condition by an act that does not serve a legitimate purpose. A hazardous condition refers to a situation that is dangerous and poses a risk of injury to others in the vicinity of the defendant's conduct. So you're standing on the street corner here in Plattsburgh, and you are swinging a machete around. Maybe you're singing your favorite song on the top of your lungs. Even without the song, singing on the top of lungs. Do you think we can get a disorderly conduct charge? You creating a hazardous condition, swinging a machete around on a street corner, especially if there's people walking by. Chances are pretty good law enforcement is going to say, you need to stop doing that. And if you don't stop doing that, you're going to get arrested for disorderly conduct. And there are many types of unruly conduct that may fit this definition of disorderly conduct. And because of that, the statutes are often used as like a catch-all for crimes. Police may use a disorderly conduct charge to keep the peace when people are behaving in a disruptive manner to themselves or others, but otherwise present no danger. Being drunk in public, standing on a street corner screaming obscenities at other people walk by. Form of disorderly conduct. What kind of criminal intent? It's usually purposely or intentionally, depending on where you are. Sometimes reckless. So specific intent, purposely cause public inconvenience, annoyance, or alarm is the language you will see, where somebody intends or purposely to cause public inconvenience, annoyance, or alarm, or reckless intent to cause a risk. That might be our person who thinks it's cool to swing around the machete on the street corner. Maybe they're juggling machetes on the street corner. And while that might not be their intent to cause public inconvenience, annoyance, or alarm, it could be deemed reckless, creating a risk of somebody getting hurt. But those are questions that a judge is going to have to sort out. The attendant circumstances. The conduct has to occur in a public place or affecting the public. Drunk and screaming obscenities in your home when you live in the middle, your house is in the middle of 300 acres. You're not probably going to get a disorderly conduct. But if you're doing that on the sidewalk in downtown Plattsburgh, likely. And the state's statute will define what a public place is. We're going to go through the ones in New York because I want to circle back to it when we talk about loitering or vagrancy. Disorderly conduct in New York is a person who they are guilty of disorderly conduct when with intent. There is our word intent. They don't use purposely. We don't use purposely in New York. Intent to cause public inconvenience, annoyance, or alarm. So when the conduct is intended to do those things, or recklessly creating the risk. So this is the same language that we've already seen a moment ago. That was actually from the Model Penal Code. The New York uses it as well. And New York has 7 ways that somebody could get a disorderly conduct charge and ultimately a conviction when he, and the statute actually does use he. They don't go back and forth, he, she. It's for both genders. He engages in fighting or in violent, tumultuous, or threatening behavior, or he makes unreasonable noise, or in a public place he uses abusive or obscene language or makes an obscene gesture. There's that obscene gesture again, flipping off the police officer. 4, without lawful authority, he disturbs any lawful assembly or meeting of persons, or he obstructs pedestrian or vehicular traffic, or he congregates with other persons in a public place and refuses to comply with a lawful order of the police to disperse, or he creates a hazardous or physical offensive condition by any act which serves no legitimate purpose. So our disorderly conduct statute here in New York has a little bit more than what's in the Model Penal Code, and it also encompasses things like loitering and potential assembly issues, right? Congregates with other persons in a public place and refuses to comply with a lawful order. We'll talk more about those. New York defines public place as a means, or it means a place to which the public or a substantial group of persons has access. So let's talk about that for a little bit. Public place in New York means a place to which the public or a substantial group of persons has access. So some of the things we can think about: the sidewalk, right? A park, the middle area of a sidewalk, or it could be a street corner. Some of the things that public has access to, it says, or a substantial group of persons has access. How about a mall? Technically, a mall is private property, but that's where the public goes in groups. So there's the potential, especially if it's happening outside in the parking lot area, potential of getting a disorderly conduct. Maybe some other charges too, but we'll cross that in a moment. Horn honking. Let's talk about the statute and how it works with disorderly conduct. We're going to use horn honking. There's a case. A woman is honking her horn in front of her neighbor's house during the night because she's mad at them for a particular reason, and I'm going to take you through the case. Washington. The Washington Supreme Court struck down a county noise ordinance that prohibits the honking of car horns for purposes other than public safety. And the court noted that they struck this down under the First Amendment because the law was over breath. So we talked about void for vagueness in Chapter 3. We'll revisit that in a moment. We did not talk about the overbreath doctrine, and we're going to do that right now. So in Snohomish County in Washington State, there was a code that prohibits sound that is a public disturbance. That was the statute. That's what it said. Sound that is a public disturbance, including the sounding of vehicle horns for purposes other than public safety. So this is in 2006, Helen Emblett honked her vehicle horn in front of her neighbor's house for 5 to 10 minutes at about 6 a.m. after learning that her neighbor had told the homeowners association that Emblett was raising chickens in violation of the association's code. A police officer arrested her after she honked her horn again in front of the neighbor's house while the officer was taking the neighbor's statement. A jury actually found her guilty of violating that ordinance. The next appeals court in Washington confirmed that conviction, but then she appealed it to the highest court in Washington, and on appeal, she continued that her argument was overbroad and violated the First Amendment. The court agreed and said that the statute was overbroad. Let's talk a little bit more about that. The court noted that the ordinance did implicate speech when individuals honk their horns to convey messages other than public safety. The judge who wrote the decision said examples might include a driver of a carpool vehicle who toots a horn to let a coworker know it's time to go, a driver who enthusiastically responds to a sign that says honk if you support your troops, wedding guests who celebrate the nuptials by sounding their horns, and a motorist who honks a horn in support of an individual picketing on a street corner. These are all ways we use our horn that do not relate to public safety. And the court further said that there were many instances where horn honking constituted protected speech, even if Miss Emblett's individual honking was not protected. The court recognized that some courts in other jurisdictions may have rejected the idea. We're going to talk about those. We declined to follow that lead. When it does not involve spoken words, horn honking may be clearly a form of expression. The court said that the county's ordinance banning such horn honking would restrict a substantial amount of protected speech, including those examples that were just provided. So the court concluded that the ordinance prohibits a wide swath of expressive conduct in order to protect against a narrow category of public disturbances. That's our overbreath doctrine. This reasoning exemplifies the spirit behind our overbreath doctrine, that some laws simply are drafted too broadly to invade the sphere of protected freedoms. So when the law encompasses way more speech than it intends to prohibit, the law is going to be shot down by the courts as being overbroad. Many laws are passed for a whole bunch of purposes. People don't want to listen to, unnecessary horn honking. And in this case, the 6 a.m. horn honking. But governments must pass laws that are drafted with precision, not restrictions that are overbroad and ill-defined. Of course, this is not our first horn honking case that's led to this challenge. Let me give you a few others so you know how this overbroad doctrine works. In Montana, the court ruled that a woman's free expression rights were not violated when she was charged with disorderly conduct after repeatedly blowing her horn to protest the location of a park for recreational vehicles near the Yellowstone River. The court ruled that horn honking in that situation did not constitute a protest to government of government acts, which would be entitled to protection. So she was there was no basis for her horn honking, according to Montana. New York came to the same conclusion. A federal court in New York rejected the First Amendment challenge to a city law. It's a New York City law stating that no person shall operate or use or cause to be operated or used any klaxon. A klaxon, if you don't know what a klaxon is one of those horns you see on a clown car. That's the only place I could give you an example of. Or a bike. They have the little black rubber thing that squeezes and it honks. That's what they're talking about. It was installed on a motor vehicle, and this case is from 1985. It wasn't like an old timer case, even though you guys might think 1985 is a long time ago, which it was. But nonetheless, those types of horns were not installed on cars. But this one was installed on a motor vehicle. And the law went on to say, except as a sound signal of imminent danger. It's the only way you can honk your horn is this kind of horn is a sound signal of imminent danger. And what he did was he was repeatedly honking his horn while stuck in Manhattan's traffic. And he argued that horn honking was a form of expressive conduct protected by the speech. The federal court in New York rejected that argument, determining that the law furthered two substantial state interests, reducing noise and maximizing the usefulness of car horns. The court also noted that the ordinance did not target the content or viewpoint of individuals honking their horns. So, New York, Montana said that the laws regarding horn honking were not unconstitutional. And one last one, Oregon did say was free expression. There was a law that ruled that a city law prohibiting horn honking for purposes other than a reasonable warning to another vehicle violated the free expression of the First Amendment. The court determined that the law was unconstitutionally overbroad. For example, it is broad enough to make honking unlawful if a motorist honked his horn as a friendly greeting to a bystander as he drives by a residence or any other circumstances where horn honking is used as a form of communication. So as you can see, disorderly conduct statutes can be quite broad, leading to these constitutional challenges. As I circle back to the obscene gestures, flipping off the police, how about swearing in public? Swearing in public. Do you think you'd be arrested for swearing in public? Hate speech, name calling, someone who's walking by you on the street corner, just shouting out names at them. That's technically protected speech. Hate speech is protected speech. We may not like it, but it's protected speech. Swearing is protected speech. So when does it become disorderly? When does it become, by the way, it is protected speech to flip off the police officer? But again, it depends on where, if you're just driving by in your car and the police officer is walking up on the street and guys happen to make eye contact and you flip off the police officer cannot come and arrest you. There has to be something else happening. So courts are reviewing specific statutes, as you can see from the cases I just mentioned. They are strictly scrutinizing them because of the fundamental right to free speech. Two common grounds, this is recap, for challenging and striking down the statute, finding the statute unconstitutional. When I say striking down the statute, is that the statute is void for vagueness or overbreadth. The two cases above involve overbreadth challenges and determinations. Those were all the arguments. Two of those cases said there was overbreadth, which means statute encompasses too much speech that is being restricted. The horn honking, preventing other things from happening. Parades, horn honking in parades, weddings. Now, void for vagueness involves a challenge to the statute as being ambiguous. And we talked about this in Chapter 3. The example that I used, I'm going to use it again now. If there was a statute that says it is illegal to distribute a violent video game to minors, right? How, as a video game store owner, the statute has a lot of issues. And this is actually a real statute in California, and it was struck down for void for vagueness. It can lead to an uneven application of the law by law enforcement, and it also needs to provide adequate notice to the public as to what conduct is criminal. So what are the problems with that? It is illegal to distribute a violent video game to minors. Where are the problems? Well, what does distribute mean? Does it mean rent, sell, lease? What constitutes violent, and who decides violent? It's kind of subjective. What I think is violent, you might not think is violent. Who is a minor? That's going to depend. You might be thinking, well, anyone who's under the age of 18. But as you have seen, as we've talked about statutes actually define ages. They're a type of attendant circumstances. So we don't know who a minor is. A minor might be 16 and under for purposes of video games, right? So it needs to identify who that is, right? So, as you can see, crimes against the public, they kind of run into constitutional issues. Strict scrutiny is the test, and the question is, does the government have a compelling interest? Let's talk about vagrancy and loitering. Historically, vagrancy laws made it a crime for a person to wander from place to place without visible means of support. Basically, these laws criminalized being homeless and jobless. States used vagrancy laws to arrest, prosecute, and harass homeless people and poor people who were suspected of criminal activity or who were considered undesirable. Now, vagrancy laws sometimes prohibited specific acts, such as loitering. Although this term can be problematic too, as I explained above with regards to void for vagueness. What constitutes falls under loitering could be sleeping outside, panhandling, fortune telling, prostitution, and there's constitutional problems with these. All laws must be constitutional, which means that no law can violate any of the provisions of the United States Constitution, and many vagrancy laws have been struck down because they violated the Constitution's prohibition against cruel and unusual punishment, or they were vague. Laws cannot, as we had talked already, laws cannot impose punishment that is cruel and unusual. Many courts have decided that status crimes are based on the person's status, whether they are homeless, begging, as such. Status crimes violate the prohibition against cruel and unusual punishment because the defendant is being punished for unfortunate circumstances beyond his or her control. Few people desire to be homeless and unemployed, and it violates the tenets of fairness to jail someone based on financial catastrophes, or could be medical problems, could be mental illness, it could be addiction. And this is also where vagueness comes in. A law must also be written so that an ordinary person can determine exactly what acts are prohibited and what people must do or refrain from doing in order to avoid criminal prosecution. Without clear guidelines for conduct, ordinary people, police officers, judges, they have no way of knowing what constitutes a crime. This violates a person's, what happens is it violates a person's right to due process, and from Chapter 3, due process, fairness. Vagrancy laws, particularly laws prohibiting loitering, have been challenged successfully in court on the basis that they are just too vague. I'm going to swing back to a few, actually, the city of Jacksonville case what I referenced in my last, when I was speaking relative to the last slide, and I'll have another one coming up. But Chicago versus Morales, vagrancy laws. This is where the state Supreme Court ruled vagrancy laws, particularly laws prohibiting loitering, have been challenged and successful in court on the basis that they are too vague. The Supreme Court has actually said that. Chicago versus Morales is the case that they say that, and it's referenced in the book. New York does not have a vagrancy statute, but does have a loitering statute, and there's 3 levels or grades as they move up, which have been under attack, and many legal professionals are calling for them to just be repealed. And law enforcement, however, though, still uses it to actually target specific individuals. In 2019, the New York City Police Department settled a lawsuit a lawsuit that was against it, that was brought by Legal Aid Society on behalf of people who asserted that police had arrested and detained them for loitering for prostitution based on personal appearance, and then claimed they were working as prostitutes. That's what the cops said. Oh, they were working as prostitutes, even though they were arresting them based on personal appearance. One cop actually admitted in a deposition that he would look for the Adam's apple when considering whether to detain a suspect for prostitutes. So really, they were looking for people who were transgender. The police department for decades has been profiling and arresting women of color, especially those who did identify as transgender, simply for how they dressed, who they spoke to, and where they socialized. So under this settlement, the New York Police Department, aside from paying out lots of money, amended the patrol guide to prohibit officers from relying only on gender identity, clothing, and location to enforce the loitering laws. The change also required officers to provide more detailed, factual narratives for why they detained someone, and also that officers would also be trained to understand that if someone has an arrest record, it is not in and of itself cause for an arrest. So let's talk a little bit more about panhandling. Do the laws against begging violate First Amendment, which is a form of speech, and it is subject to constitutional attack, and it's going to depend on where it is taking place and what else is happening. And this will circle us also back around to the disorderly conduct and flipping off the police officer. Outside a mall. Let's talk about outside the mall doors. Mall is a private entity, so it's private property. So you may not be arrested for panhandling or loitering, maybe trespass, because you're not allowed to be there. Let's talk about public places. Traditional public forums, public places. That's the fancy term that the court will use, a traditional public forum, when looking at where this is happening. And if it's happening in a park, on a sidewalk, that is protected speech because it is a traditional public forum. They have to be engaging in some other conduct. So generally, these statutes require aggressive conduct or conduct that blocks public access or the regular flow of traffic, as well as a review of where it's happening. Our next spot, what if it's a public place? It's owned by the government. What would be something that's a public place that's owned by the government? Post office, military base, a court. Are these generally types of places for regular public access? For business. This is not a type of place where you can go and hand out your pamphlets or hold an assembly, get together. And it's certainly not a place where panhandling can take place. So they're considered non-public forums. They may be a public place, but they are non-public forums, which means the government can restrict these more freely. And generally, you're going to find this type of crime to be found in a city or a local code. New York City has such a statute. Let's talk about the one in the middle, the designated public forums. Designated public forums is a place that the government says, yes, these places here, they may not be traditional public forums like a sidewalk or a park, but we are designating them as a public forum. And this might be something where, it could be a city designated building. It could be something, a fairgrounds is usually deemed a designated public forum. And it could just be for a period of time. Just because the government says, I'm declaring this fairgrounds as a public forum for traditional public forum access, they could say for the month of May. They could totally designate it. And they call this kind of regulation time, place, manner restrictions. It's going to depend on the level of review that the court has to do. Meaning that whole strict scrutiny test is really strict if we're talking about a traditional public forum. They will scrutinize that statute if they are violating conduct that is happening in a park, on a sidewalk. In a designated public forum, that same test will apply if the government has designated a location to be like a traditional public forum. It will have that same review. The non-public forums, though, our post offices and our military base, that's going to be a lot less review. It's going to be, is it reasonable? Is that law reasonable under the circumstances of why we're allowing that? That's why we have these different types of forums that have been designated for things like, and not just panhandling, loitering, disorderly conduct, and in some places vagrancy, but most states have shot down mere vagrancy laws and treat them as some form of loitering. And as you recall back from the New York disorderly conduct, I can't flip back in the video, but there were 7 ways to get a disorderly conduct charge in New York, and one of them is congregating in some fashion. And if you're doing that on a sidewalk, some other conduct has to follow. And lastly, I want to touch on sit-and lie laws, not sit-ins, sit and lie laws. They prohibit somebody from sitting and lying on public streets and sidewalks, right? But you can't go late in the middle of the street. I mean, a lot of folks do try and block the street, and then they wonder why they get arrested. Here is why. You cannot prevent or blocking access to business and roadways. These laws encourage people to keep moving, and you can't disrupt the flow of traffic on sidewalks or on the streets. And when we get into group conduct, assembly, when we kind of touch on protests, this is one of the reasons why you cannot just block access. So, other crimes against public, we're going to talk about moving forward. We're going to talk about the next topic is assembly, group conduct. We're going to focus on assembly, when you can do it, when you can't do it, at what point can the government regulate this constitutional protected right to assemble.